All hail Biafra. This is Biafra Liberation Army Network coming to you again. Please do subscribe, like, share, and comment.
I want the world to know that Nnamdi is not facing any prosecution. Nnamdi is facing persecution. Persecution in the sense that since the history of law in Nigeria, it's well established that Nnamdi is the only defendant in the history of law in Nigeria that does not have adequate time and facility as provided by Section 36 of the Constitution, which gave an accused person a right to have adequate time and facility to defend himself. What do I mean? You recall that some time ago, as his lawyer, when I went to have a discussion with him at the DSSS, my right was violated, I was intimidated, I was stripped to half naked there in DSSS. I rushed back to the Federal High Court and lay my complaint through originating processes. And after looking at all that happened, the court said yes, Nnamdi lawyer's rights was violated, granted all my release, and directed the DSSS to apologize to us and stop intimidating us and to pay me 5 million naira. That particular judgment was not appealed against. That particular judgment is still subsisting and valid. Now, we took the same application to the same Federal High Court, stating the reasons why Nnamdi should be taken away from DSSS. DSSS is a prosecution. You don't need to have a law degree for you to know that you can never be a judge in your own case. The principle of nemo juris casasua. You can never be a judge in your own case. Anytime we went to DSSS to have a discussion with our client Nnamdi, the DSSS will set up gadgets, send the officials to come and monitor what we are saying. Right from the gate, they will search us. Whatever documents that the confidential documents that I'm going with to discuss with my client, they will collect it, take it to the legal department. The legal department will read it, photocopy it before they will hand it over to us. Whatever minutes I collected from Nnamdi, as I'm coming out, they will collect it from me and snap it. So, in other words, there is no somebody that was arrested. I'm talking about was Wadume was arrested and he was released. We are talking about to name them, Kabiru Soko them, name a lot of them that were released. Not to talk about somebody that is fighting for the right of his people simply because you feel that he's an Igbo and you think that you can intimidate him. No, nobody intimidates anybody because after 8 years, after 4 years or 8 years, as the case may be, you will leave, another person will come. So try and do something so that you write your name in the Guinness Book of Record. As we speak to you now, we have not been able to have a conference with our client. That one is one. As a lawyer, my rules instructed me that for me to enter into a matter, I must have adequate conference with my client.
By now should be arrested and brought to book. Nigeria, like I said before, as far as we are concerned, until they purge themselves of this crime, remains a criminal country. It is unfortunate, it is our country, but that is the position. Until Nigeria purges itself of this crime of kidnap that it has committed against Nnamdi Kanu, remains a criminal country and ought to be dealt with in that fashion. Nnamdi Kanu committed no crime known to any law. Just because he's asking for self-determination for his people, which is supported by the African Charter is supported by the United Nations Charter also on Human and People's Rights. It is supported by our Constitution. For this reason, he is being persecuted, not persecuted. For the federal government of Nigeria to have kept him in detention in a solitary confinement for 3 years is persecution. There is no law supporting this impunity. There is no law supporting this illegality. There is no law supporting this breach of our Constitution. If somebody has committed a crime, according to our Administration of Criminal Justice Act, Section 169, such a person should be detained in a prison if you must detain the person. But in this case, no crime has been committed, no antagonistic move has been made against the Constitution. Every action taken by Nnamdi Kanu has the benefit of constitutional protection. Self-determination, calling for self-determination is not a crime. Asking for a referendum to determine whether this nation called Nigeria or this political arrangement called Nigeria should stand or not is a matter of his belief, something that ought to be discussed and agreed upon. Nigeria was amalgamated in 1914 under Lord Lugard, and under the influence of romantic relationship, the name Nigeria was ascribed to this part of the country or this part of the world. Our fathers, our ancestors did not agree to an amalgamation in the first place. Our ancestors did not agree to being named Nigeria. Our ancestors did not agree to surrendering their individual and community sovereignty, but this was obtained under the barrels of the machine gun and possibly under the influence of alcohol by Lord Lugard and his girlfriend. And today we are all suffering that consequence. We are all suffering that false unity. We are all suffering these political arrangements. We also all know and we also all agree that in Nigeria, this country today does not have a valid constitution that you can rely or call a constitution. The people of the Federal Republic of Nigeria, as we are called, or as we are being forced to bear, have never met one day to agree to have a constitution. So the preamble of the 1999 Constitution is based on falsity, based on lies, that we, the people of the Federal Republic of Nigeria, has given unto ourselves a constitution. We did not give to ourselves any constitution. The constitution is an extension of a decree of the military juntas that was in power at the time in question. It is not the intention of the people of the Federal Republic of Nigeria, as we are being forced to bear, to have that document as our constitution. But because we cannot continue to operate in a vacuum, we are managing it. And even in managing it, the federal government today has consistently refused to respect and obey its constitution. Or I would say its so-called constitution. The Federal Republic of Nigeria, as far as we understand it and as far as we are concerned, does not have a binding law that holds us together. The arrangement is a military arrangement in all ramifications. Lord Lugard came with his machine guns to hold us together. The military came with their machine guns and bombs to force us to swallow a constitution, a document called Constitution. So until the people of Nigeria come together to decide whether they want to remain a nation, we cannot say that we have a nation. Now, some will say it is the National Assembly that has the powers to determine such. We beg to disagree on this. The National Assembly does not have the power because in the first place, the Constitution of the National Assembly is made from the false document called the 1999 Constitution. You cannot place something on nothing and expect it to stand. You cannot build a mansion on lies. The people of Nigeria today did not sit at any time to have a constitution. A military decree was made, and we are forced to take it and adopt it and accept it as our constitution. But ordinarily, I was not represented. People from my community were never represented in that constitution-making process. And I'm sure even members know flex the common position of all the lawyers here, the position of the MNK legal team. This legal team is not going to be part of the travesty of justice that is being cooked in the pot. If Nnamdi Kanu is not going to get a fair trial, this legal team is not going to be part of murdering justice in a Nigerian court over the head of President Nnamdi Kanu. It does not mean we are going to abandon Nnamdi Kanu, but we will, as a group, as a team, abandon a process. We will refuse to be participants in a process that is geared to pre-program the injustice on the head of Nnamdi Kanu. Let that be clear. So it does not sound like we are going to boycott Nnamdi Kanu. No. If you want to say we shall boycott the judiciary, you can use that. But what we are boycotting will be manifest injustice and lack of fair trial.
They can go ahead and convict him without him being.
The cat cannot come before the horse. The horse must come before the cat. And what is the horse? Fair hearing. And the cat is the accelerated hearing. You cannot have any criminal trial without fair hearing. That is the point we are trying to make. And this message is being sent loud and clear to the Federal Republic of Nigeria and to the Nigerian judiciary. Thank you very much for coming, and you have a nice day.